The state is empowered to withdraw a charge pending either further investigations. If the state gets any more evidence, they will still arrest the suspects that have been cleared, discharged, and be brought to court. That is the provision of Section 87A. So the state is within the law. They will still continue going to investigate. And our position is, let them not continue to invoke Section 87A every other time. Let them bring cases to court of people who they have done investigations and they have completed that investigation.
It is clear that even at this moment
of the NYS matters, in total there are more than around 53 accused people. The state indicated that they want to amend the charge sheet. The last time we were in court, it was allowed to amend the charge sheet. Today they came with a new charge sheet of 30 people. They have removed 10 people under Section 87A of the Criminal Procedure Code. They have withdrawn the charges. So those people are free, innocent. And the question that is there is one, the NYS suspects took a plea way back in September 2018. To date, the state has not decided who to charge and who not to charge. They are continuously withdrawing charges against the accused person. Is it clear the DPP had not done thorough investigations to make a decision who to charge? Is it that now the state is doing its investigation at this time? This is September. This was September. This is January. We hope again the state will not still continue to withdraw charges against the accused person. As the defense team, we have always been ready to proceed with the hearing of this matter. The judiciary that is being blamed that it is not ready to hear and determine these matters is now very clear that there is nothing to be had. Because if the state, every time they are withdrawing the charge, a new charge sheet and new counts must be read to the remaining people, then this trial will start. If this type of musical chairs will proceed, then I don't think the state is prepared, the DPP is prepared for this matter to proceed. And the defense team for the accused person, this is a gross miscarriage of justice. Some of our clients were charged, they were published, the newspapers were published all over, that they indeed were criminals. Several cases are likely to floodgate the courts for defamation. These people, the 10 whose cases have been withdrawn, were already interdicted. They were on half pay. They will go back to work, having been cleared from the court process. But the injuries that have been occasioned to their reputation, to their financial standing, some of them, their children have not gone to school, the amount of cash bail that they were told to pay of 1 million shillings was exorbitant. And remember, these are the people who at one time were denied bail until we had to go to the High Court to challenge for them to get bail. We urge the DPP to only bring people, suspects that the watertight cases are really watertight cases, not watertight cases by talk. Let the state be sure. There's no hurry. We have always, as defense team said, the state is in a hurry to bring so many people to court. And now the reality is there that very many their charges are being withdrawn one by one by one. Are we likely to see nobody being taken through the trial process in this NYS trial, if this is the trend that the state seems to be taking? So our take as the defense team is that we are ready, prepared to argue the case, defend the case. The judiciary has always been ready to proceed with the hearing. The problem is the DPP. They are not sure who to charge because they are still doing their investigations to date. And if this trend continues, there's a likelihood that all the cases that have been dragged before the anti-corruption court are likely to be withdrawn.
Under which section is the withdrawal, and can you plan for this?